So good afternoon, everyone. I am Kathy Neifeld. I'm one of the partners at AgencyONE, and we are thrilled to bring you this webinar with our friends from John Hancock on the Connelly decision, which was handed down, I believe, the week before last. And this is a decision that is extremely important to every business owner that has a buy-sell agreement in place. And if they don't have a buy-sell agreement in place, perhaps they should, and they need to know what the Connelly decision has said. So if you are an advisor that is working with business owners, thank you for tuning in. And if you are not working with business owners and figure you needed some talking points in order to have someone pay attention to you, this could not be any more topical for you to use this as a door opener. So our featured speaker today is Tracey Ullom from John Hancock. And Tracey is one of the associate counsels with the Advanced Markets Department at John Hancock. And in her current position, she provides case consultation, technical expertise, and marketing support to BGAs like AgencyONE and to advisors like you guys on this webinar. Tracey, when we were planning this webinar, I had to laugh because, as most of you know, we work extremely closely with Wayne Baldwin, who is always a phenomenal support to us at AgencyONE. And Wayne said, well, if you want to do a webinar on Connelly, we need to get Tracey on the phone right now because she was listening to this decision in real time and following this case through the lower courts. So we were thrilled that Tracey was available and can be here to guide us through the decision and the planning opportunities as a result of that. Just a few housekeeping notes. If you have any questions, we would like you to type them into the chat, and I will refer them over to Tracey. There will be some specific breaks in between some topics that Tracey is going to talk about that we will be able to open up for questions as well. But just in order to keep this within some kind of order, we would appreciate it if you would type it into the chat. So without further ado, I am going to turn it over to Tracey. Thank you very much.
Thank you very much, Kathy. And I'm really glad to be here with AgencyONE today. AgencyONE was one of the first BGAs that reached out and said, we need to get in front of our folks and have this conversation. So I'm really excited to share kind of what we know on the topic, as well as provide you with some information that you can use in real time when out talking, because this really did bring to light some new changes to our industry, and kind of is going to change how we plan and do buy-sell planning differently than we've done in the past. So really, as far as an agenda today, we're going to go through a lot. So wanted to kind of break it down a little bit, kind of start from, what's leading into this, what happened in the case itself in the lower courts, what did the Supreme Court actually decide, what the impact of that decision is going to be, what does it mean for buy-sell planning, for our industry, for our clients, what does it mean for those folks that already have these types of buy-sells in place, as well as provide some planning opportunities as far as opportunities for alternatives in the marketplace, and kind of how we can shift, or how we're going to talk about buy-sell maybe a little bit differently going forward. So really, just to start, the conversation is all about that business owner succession, business succession planning. What happens if something happens to a business partner? What happens to my business if something happens to me? Wanting to make sure that the spouse, children, or another third party is able to kind of come in and take over the business at an approved value, at a fair value, and essentially that transition happens in a way that keeps the current business partner, the remaining business partner, as well as the heirs and children of the other business partner kind of in with expectations that they can follow. So really, the buy-sell agreement is there to provide that cash for spouse and children, secure the buyer for that ownership interest, establish a value for that business interest, and well as just facilitate that transfer of that business either to the next generation or to the next ownership structure. So why is this important? Again, really starting with, for a while now, I've been talking a lot about buy-sell planning as far as getting buy-sell planning in place for businesses. And this conversation is not just about what's changed in the buy-sell arena with that landscape because of this case, but also it gives us the opportunity to open the door and to have those conversations with folks that say, hey, something's changed here. Are you in the right place? Do you have your buy-sell agreement set up? Are you following the terms of your buy-sell? And can I help you with that planning? And really, it is extremely important. I like to start with numbers as far as kind of why this conversation really needs to occur now. And what we know from recent studies is that 2/3 of business owners actually do not have a documented and communicated succession plan for their business. However, almost 80% of business owners say that the business is really their most important asset, and protecting it is that top long-term goal. So it's hard to really reconcile those two numbers with 80% of people saying it's their most valued asset, but only 2/3 of people saying that they actually have prepared the necessary documents and plan to what happens with that asset should something happen to them. And then we talk about, not just from that planning perspective, but what's the opportunity as far as businesses actually transitioning and needing that succession plan in the near future. Studies have shown that about 50% of US businesses are owned by baby boomers, and they're set to transition in about 10 years. But it also estimates that about 30% of businesses are actually successfully sold or actually are sold at the value that the business owner believes that they should be sold at. So really a great opportunity for us to be out in the market, really engaging with business owners and making sure that these plans are not only in place, that they're adequately funded, that they have the plan, that their partners, their heirs, their family know what the plan is should something happen for that succession requirement. So really what we're talking about, and we'll talk a little bit more about kind of the different types of buy-sell agreements, but really at its core, the buy-sell agreement is really just a legally binding contract that provides for the transfer of ownership and continuation of the business at death, disability, retirement, or for another triggering event. So it is really crucial for a closely held business to have that contract in place so that the business owners can sleep well at night knowing exactly what's going to happen if one of these events actually does occur. There are a variety of types of agreements and arrangements available. We'll talk a little bit about all of them, but these buy-sells will always look different depending on the number of partners in the business. Is it a family-owned business? So are we looking to transition to the next generation? Are there active participants, or are there participants in the business that may have more of a passive interest but not be actively participating? We'll also, and it may change depending on whether there's multi-owner, single owner, and other kind of key factors in determining which type of buy-sell arrangement fits for each business owner. So before we get into kind of how everything changed and what happened, I'm going to spend just a little bit of time giving a little bit more of a background because it always helps to understand kind of where we were, to know what happened, why it's important to what happened, and then where does it go from here. So what I'm going to refer to as those traditional buy-sell options are often structured and funded in one of two ways. So we've heard of these before, the cross-purchase agreement, as well as an entity purchase or stock redemption agreement. So in a cross-purchase plan, each owner essentially agrees to personally buy the interest of the departing owner upon a triggering event, and each owner purchases life insurance on the lives of the other. Cross-reference that with the entity purchase plan, also known as stock redemption. The business entity itself agrees to buy back the departing owner's interest upon a triggering event. So in this plan, the business owns a life insurance policy on each business owner and agrees to use the proceeds to redeem the stock of a business owner upon death, retirement, or disability. What we know in the marketplace, kind of, this is again that setting the stage of of kind of everything else that comes through is that in a cross-purchase arrangement, some of the drawbacks, or when we wouldn't see this used, is typically if there's too many owners, because of course it's too many policies. Then if we've got 3 owners, that ends up with 6 different life policies because each owner is purchasing a policy on each other partner. There's discrepancies as far as different ages and health, as far as how much premium payment each of those owners has to pay for the other policies. There's concerns about where the premium source is coming from, whether it's in a form of a bonus arrangement coming from the business, or if they're using personal funds to do this, and ultimately leading to potential mistrust, understanding that my partner has to maintain that policy on my life, and unwinding it in the future, trying to, change ownership on policies. There may be values associated with that might not coincide with each other. Cross that with the entity purchase stock redemption. Some of the drawbacks that we've seen are some people don't like the entity purchase. They don't get a step up in basis for survivors when they go to purchase the outstanding shares, because again, the business itself is purchasing them back. If owners are not looking for that pro rata increase, so we're going to shift a little bit more to one side versus the other, or it's not going to be an equal share essentially at the death of one owner. And of course, and we'll talk much more in depth about the concerns post Connelly. So let's get into the Connelly case. So I'm going to cover the facts in pretty high detail. This is actually different in a presentation style than what I was giving pre the Supreme Court decision, because we really believed in the industry and when talking through this case that the facts were really pertinent to what the outcome was going to be. This was definitely a case of bad facts equals bad law when we were looking at those earlier court decisions. And I'll talk about kind of how that happened, and then ultimately why at this point we're not going to be talking about these underlying facts anymore, that they really didn't matter when we got the court's decision on June 6th. So just a little bit of background. So 2 brothers, in this case, Michael was a 77% owner and Thomas was a 23% owner, owned a C corporation building materials company. The 2 brothers, Michael and Thomas, had entered into an entity redemption agreement where the company value was to be determined annually in the agreement stated mutual consent. And if they died and no mutual consent value was available, then the value was going to be set by an average of at least 2 qualified appraisers. At the time they entered into this entity redemption agreement, the corporation bought $3.5 million on each brother to fund the redemption obligations. Now keep in mind, they bought 3.5 on each brother, but one brother owned 77% and the other brother owned 23%. So we do see that sometimes, but that could lead into kind of some of the facts that we're going to talk about and what happened after the case. So Michael, the 77% owner, dies in 2013. As part of the transition under that entity redemption agreement, because they hadn't ever done a mutual valuation, or they didn't have a mutual consent valuation at the day of death, they also didn't do any appraisals. They didn't obtain any appraisals. It was essentially a mutual consent after death. Thomas negotiated the sale with Michael's son that the value of the business was to be agreed upon value of $3 million. And so Michael's estate filed a tax return, or an estate tax return, showing a value of $3 million for that business. Of course, then the IRS audits and all of this case pursues. So when we look at the audit, what happened here? So the IRS ended up valuing the decedent's shares at almost double what the estate claimed. So the IRS in this case said that the 2 brothers never adhered to their buy-sell agreement. They never got those valuations. So therefore, because the agreement wasn't valid, they had never adhered to it, they never followed the terms of the agreement, that the agreement couldn't create that offsetting liability to essentially offset the value of the shares in the value of the business. So the IRS included the $3.5 million death benefit in the value of the C corporation, And essentially, the estate had then decided to gross up the value or offset that grossed up value by that contractual obligation to redeem. In this case, the court ignored the owner's entity redemption agreement. So this was a case where the question was under Code Section 2703, where for estate tax valuation purposes, the property value for tax can be determined with, or has to be determined without regard to any agreement, unless it requires a fair market price or method for determining it. And then there's also an offset to estate tax where they can essentially deduct a liability, an offsetting liability, contractually liability. So in this case, what they did as far as the agreement and the buy-sell in determining the estate tax was the estate said the value of the business did include the life insurance, but it was offset by that offsetting liability for the redemption. And the IRS said, no, we're not going to consider the agreement because it cannot be offset by an obligation under the agreement when they didn't follow that actual agreement that they had. So that was the Eighth Court. So before we get to that, it went up to the Supreme Court because we had a decision out of the 11th Circuit called Blount v. the Commissioner, where on the flip side of this, the court, in that case, the appeals court had ruled previously that the life insurance policy, the value of that was not includable in the value of the business for estate tax purposes because of that obligation to redeem the shares presented an offsetting liability. So the court in that case essentially had said that no reasonable buyer would come in and pay the fair market value of the business, including the life insurance death benefit proceeds, knowing that there was still that obligation to redeem using that same value. So that's kind of where we've been operating as an industry for a long time, was under that decision stating not necessarily that the life insurance wasn't includable in the value of the business, but rather that it could be offset and essentially deducted from the value because of the buy-sell arrangement, creating that liability. What happened from the Supreme Court level was that the question presented was, should the proceeds of a life insurance policy taken out on a shareholder's life to facilitate a stock redemption be considered a corporate asset when calculating the value of the shareholders' shares for estate taxes? And the Supreme Court, or in this case, we refer to them as SCOTUS, SCOTUS affirmed the Eighth Court's decision and essentially said that for purposes of estate tax value, the life insurance is includable when deciding what the value of the business is going to be, and no offsetting liability is allowed. So, in other words, that contractual obligation, that buy-sell agreement that says that there's an obligation to redeem the shares, is not necessarily a liability that reduces the corporation's value for estate tax purposes. Therefore, in this case, they then valued Michael's shares at about $6.85 million, which would have included the value of those life insurance proceeds without any consideration of the fact that there had to be a redemption. It said that that contractual obligation to redeem does not offset value, and for estate tax purposes, the value of the business is to be determined at the date of death. And in this case, they said that the obligation doesn't occur until after that date. Therefore, there's no liability offset.
Tracey, we had a question that came in, which I think is great to ask right now.
Yeah.
Which was, if the business had had a current valuation, would the offset or the buyback allowance been allowed or not?
So unfortunately, we'll never know. And that's the hardest thing with this case. And like I said, I went into a few of the facts associated with the case, because all along when we were looking at the lower courts, the facts were so pertinent to the decisions that were happening on whether or not that offsetting liability was allowed, because they never followed the agreement. Unfortunately, what we got back from the Supreme Court was a 4-page decision that did not cover the facts. They never talked about the facts. They never determined whether or not the buy-sell arrangement was valid. They never went into any of those considerations. And what we ultimately ended up with was a very broad brushstroke decision that really affects all entity purchase arrangements. And it's unfortunate because I don't know, and I don't believe that the Supreme Court thought that they were doing something like that. The Supreme Court came in and in several cases in their argument stated that this was a very narrow decision and applies to this specific scenario. However, never brought out the facts to allow us to apply it very narrowly, and ultimately just said that there's no offset for in entity redemption agreements. Unfortunately, they did also go into there was also an argument from Thomas's lawyer and the Connelly's lawyer that said, well, this decision will turn buy-sell planning for small businesses on its head. And the court rejected that thoroughly and said that it was that the decision affected this scenario because of the type of buy-sell that they chose to use, and that they could have done something different vis-a-vis a cross-purchase arrangement, which is true, but it really misses that opportunity or that point that they had to really narrow this decision, and they chose not to. So I do, and myself and other folks in the industry, we've been talking about this because we know the facts behind this case, not necessarily sure that this is the wrong decision for this case. I ultimately, and many folks believe that based on the facts, that they may have ended up in the right place for this case. The problem is that they applied it very far reaching, and I don't think that was the intention. However, that's where we ended up. There is, however, a footnote, footnote 2, at the very bottom of the last page of the argument, that where the Supreme Court did provide or did state that there could be circumstances where a redemption agreement would reduce the value of the corporation, but it suggests a very narrow exception. And the exception that they give is if the buy-sell agreement or the redemption required sales of capital assets that would then reduce the ability for the business to earn or reduce the earning capacity. So the question becomes, we can't rely on a footnote, and we can't cite to a footnote necessarily as precedent, but it remains to be seen kind of how that gets interpreted and at what point in time, the question is if we're informally funding through life insurance, so similar to like what we see in non-qualified deferred comp arrangements, where the life insurance is still an asset of the business, but it's not tied directly to that liability. If we're not technically tying the life insurance directly to that obligation, rather there's a need to use capital assets for that redemption, and maybe the cash becomes capital assets, things like that. So if it's not directly tied, does that somehow change that calculation? We don't know. The problem that we have is that right now, this when we talk to folks, when I've talked to colleagues across law firms and across other carriers, things like that, everybody kind of has the same reading of the case, that it was very broad, and nobody really wants to be the test case to test that footnote. And so it's yet to be seen. We really don't know how Connelly will be applied through future case law. So unfortunately, there's going to be a lot of open-ended questions we still have on the impact and how we move forward with especially current entity purchase arrangements that we won't have answers for until we get actual case law and we get application. But that doesn't happen until the IRS starts auditing more of these, or until we start having more litigation on whether or not the value of the business includes or doesn't include, or how does it get offset, or how does the liabilities work. So that's it. Unfortunately, I don't have great answers on what now or how do we apply this. It's really those big open-ended questions. So what we know and what we're running with as an industry is really entity redemption agreements should be reevaluated. especially if there's an estate tax issue that these business owners are dealing with. We really need to look and see, does that insurance that's held at the business level, that's owned by the business, thereby increasing the value of the business, does that create a higher estate tax issue? Is there another way, or should we be considering alternatives to the entity redemption arrangement? We can look at maybe migrating from that entity agreement to some other alternative structures. But there's some pretty big implications that we have to understand when doing that as well. So some of the questions to ask and some of the things to consider in unwinding an entity redemption buy sell is, is there a transfer for value question? So if we have entity owned agreement or entity owned policies and we start transferring or trying to unwind those out of the business, do we end up with transfer for value issues? Again, there's no exception for a shareholder of the insured under the transfer for value rules. Unwinding the entity purchase arrangement to something more in line, and we'll talk more about the insurance LLC, which I think is where a lot of folks are kind of heading. When we talk about that transfer for value, the IRS has actually issued a no rule notice on whether or not a transfer from a corporation directly to an LLC for purposes of buy-sell planning violates the transfer for value rule. They're just not going to rule on it. They're not going to do a private letter ruling. They're not going to consider that question, and they're not going to give us an answer. So that really kind of gives us a little bit of a frustration there, I guess, because we can't advise our clients one way or the other on that. The other thing to think about in a lot of these cases is there tax consequences for transferring the policies out of the business? Keep in mind that in the corporate space, corporations, businesses cannot make gifts. So there's no gifting available. So anytime we're transferring assets, in this case policies, there could be income tax consequences as well, or we're looking at valuing policies for sales, which can also lead to more questions as well as income tax consequences either for the partners or for the business, depending on the status of those policies and whether or not they're in a gain position or otherwise. Additionally, for a lot of these types of arrangements, the policies are held not only for purposes of the buy-sell arrangement, but also kind of like key person insurance. So we want to make sure if we're unwinding the entity buy-sell that we're not, undermining the business. If they have a key person need, maybe it's a reposition of that policy from it funding the buy-sell to really being a key person insurance. And we've always kind of operated on the fact that key person insurance as an asset of the business increases the value. So considering how much is actually needed at the business and reevaluating all of the insurance needs that these clients have, and then working directly with legal counsel that can help answer, what do they need? What does buy-sell planning look like? What are those tax implications is really going to be important and moving forward for those clients that have current entity redemption agreements that may now struggle or have a hard time because of the Supreme Court decision that we've had. So Tracey, I can stop there for a minute.
We've got a number of questions that just came in. So one of them was, under what scenario would an entity purchase be recommended, assuming no planning has been completed?
Yeah, so the Supreme Court didn't say that an entity redemption, stock redemption plan was not good. They just said that insurance is included in the value when determining it for estate tax purposes. So we're still going to see entity redemption agreements a lot. So primarily we're likely to see them in cases where there's no estate tax issue. So we've always operated under the assumption that life insurance payable to a business can increase the value of the business. We're still able to, but if there's no estate tax issue, then we're not worried. We're not as worried necessarily about reporting that for a tax consequence. There is still going to be issues. Do we have enough insurance to cover that need if because the value might be increased by the insurance even being there? Another situation is extremely large C corporations with many owners. There may still, the entity redemption agreement may still be a viable option just because of the ability for the corporation to actually manage it. In those cases, a cross-purchase arrangement may not be feasible, and some of the other alternatives that we'll talk about may not be feasible either. So they may still be kind of stuck in place with these stock redemption plans. And I think when reading the Supreme Court decision, it's unfortunate, but I think that they were struggling to understand the difference between a closely held business doing a stock redemption plan and what we talk about as stock redemption plans in the very large C corporation corporate world. So I think they were looking at it more from the corporate perspective and less from kind of that small, closely held business perspective that we deal with day in and day out.
Thank you. So just as you're moving forward, one of the questions, and I know you're going to get to it, is what are the primary advantages of using an insurance LLC instead of a basic cross-purchase agreement? And I know we're going to get to that. I just wanted to bring that up. And I'm going to give a shout out to Peter Kaplan, who gave a side comment in the Q&A, which said, just sell more trust-owned insurance to cover the increased estate taxes. Well said, Peter.
Yes,
so
that's not includable in their estate. We know that. We can still have
yeah. So let's keep going.
Yeah, and that may very well be part of the answer for those businesses that it's not feasible for them to unwind an entity purchase arrangement. So again, this is all about helping with a review, and that's really the crux. And the questions to ask when working with business owners, it's not necessarily of looking for opportunities for new business buy-sell arrangements, which we always look for as well, but it's also looking at those business owners that say that they have a buy-sell in place. Are they following the buy-sell that they have? Is there another structure that would be better suited for their situation? Has value changed? Has ownership changed since the last time that they reviewed that buy-sell? Who's designated as the buyer of the interest? Is it a company? Is it other owners? We've seen in the market a lot of wait and see buy sells, I think, and that's going to cause an issue as well, because in those cases, typically the business or the entity is the owner of that insurance as well in those cases. So moving forward, we're going to talk about two alternatives. The first one I'm going to talk about is the cross endorsement buy sell, and then we're going to get to the insurance LLC. So as the first alternative, the cross endorsement buy sell, in this case, it's a little bit different. In this case, we're going to see each owner actually owning a policy on his or her life and endorsing part of the death benefit over to their partners or to their partners. In these cases, the rental fee for that endorsement is we're going to charge an annual economic benefit. So similar to those folks that have worked through the split dollar regulations. And then in the case when an owner dies, the death benefit endorsed to the co-owners is received income tax free, and those funds are used to purchase the business interests of the deceased owner. So again, they're getting that endorsed amount, and then they're using that to purchase back the shares. Again, any death benefit exceeding the endorsed amount is going to be paid to the insured's designated beneficiaries directly. And then we can also use policy cash values to supplement the owner's retirement income. In this case, what we're talking about is really a personally owned policy to help effectuate what would otherwise be a cross-purchase arrangement. I'm going to get a little bit more into detail on kind of how this looks and what it looks like and the pros and cons. But just up front, one of the things that I always like to start with is the cross endorsement buy sell is a great opportunity. We're seeing a lot of shift to this arrangement instead of the cross purchase arrangement where we're owning policies on each other's lives. However, this is an arrangement that's not available for corporate owners. So this is an arrangement that we would see for partnerships, LLCs taxed as partnerships. But if they're a C corporation, we have transfer for value issues with that endorsement. So just want to kind of preface that up front. So what it looks like in these cases is that each individual business owner would own their own policy on their own life and would put an endorsement on the policy to their business owner for the amount that would be required for their buy-sell obligations. And in doing so, because their other business owner, in this case, Jacob, would be endorsing to Spence, because Spence is receiving that annual benefit of that endorsement, there would be essentially a rental fee of the economic benefit back to Jacob. In this case, it would be about $550 based on our current annual renewable term rates, or in other words, the PS58 costs. So sometimes it's always helpful to kind of look at these things in light of a case study. So in this case study, we're going to talk about a business valued at $2 million. In this case, 3 owners, Jim, Ron, and Ralph. Jim and Ron are 25% owners and are younger. Ralph is a 50% owner and a little bit older. So as the owner concerns, Jim and Ron are more, as younger owners, are more concerned with retirement income in addition to the buy-sell needs. Ralph's retirement is covered, but he's significant death benefit need. And all are concerned with more long-term care impacting their retirement income needs. Again, because these are individually owned policies, that we can have the long-term care rider on this, which is not allowable or not offered when owned by a third party. So if we have an entity-owned policy or we're doing a cross-purchase arrangement, we can't include the long-term care on those policies. But in this case, because each business owner owns their own policy, it is available. So it can be another really great opportunity. So again, we kind of walked through why entity purchase stock redemption as well as cross-purchase may not work in these types of cases. So I'll move through a little bit quicker. So the advantages of SEBS or the cross endorsement, again, long-term care is available. There's easy execution of the plan at death. Again, the endorsement is automatically paid and then used as cash to purchase back that shareholder's interest. Because each individual is buying it out individually, because it's essentially completing that cross-purchase agreement, there is a step up in basis in the value for each remaining shareholder at the death. There's also easy termination of the plan, either at retirement or sale of the business. Again, we just cross up that endorsement. There's no transfer of ownership of the policies, and each owner still receives or still personally owns their policy after that endorsement has been removed. In this case, each owner also would fund and own their own policy. So there's maximum flexibility in the type of the policy that they own, how they fund the policy, and the amount of death benefit that they ultimately do end up getting. So in this case, I've seen cases where we have not only a personal need, but also a buy-sell need. So we'll do one policy and of a higher amount, and then just endorse what we need over for the buy-sell while we still need it. But in the interim, the policy owner still has that individual coverage that's whatever's above and beyond what they need for the buy-sell or what's part of that endorsement. So again, they're going through underwriting once for one policy that can do a little bit of both. So in this case, for Jim, Ron, and Ralph, we did the protection IUL policy for each of them. Death benefit, again, for a $2 million company, we've got the 2 Jim and Ron with $500,000 at 25%. Ralph with $1 million at 50%. Premiums are based on how they design the policy. In this case, we were able, because they have individual policies, we're designing them differently. For Jim and Ron, we were able to get them retirement income, in this case, for Jim, about $40,000 in 15 years while he, or once he retires. And again, for Ron, about $32,000 for 15 years. Again, each one of them is paying economic benefit to each other partner during the year and is receiving economic benefit payment back to them from each as well for those endorsements. That economic benefit payment received is taxable, but it's typically pretty low in comparison to taking distributions from the company and things along those lines for payment of the premiums themselves. So we've got a nice chart, and we'll get some marketing materials, some information over if folks want to see these charts and kind of walk through it in a little bit more detail. But ultimately, at the end of everything, again, it's individually owned life insurance with the endorsement. Economic benefit is based on the ART rates each year. So we can do that calculation pretty quickly as far as to determine that quote unquote rental charge for that value. So multiple policies are not required for cross-purchase obligations. Again, underlying all of this is a cross-purchase agreement. We're just using these cross-endorsement policies in order to fund that arrangement. The endorsement can cover multiple owners and be changed and updated regularly. So administration and flexibility is a little bit bigger here. Policies, again, can be customized by each owner. And owners can combine business, retirement, and estate planning all into one policy. This can also be owned. Each of these policies can be owned in their ILET or in their trust. So it doesn't have to necessarily be a personal policy owned outright. This can be a policy owned in trust with those endorsements for buy-sell obligations as well. Would just be managed by the trustee then for the endorsement aspect of it. Again, transfer for value issues for corporations, so it may not be appropriate for strictly corporate owners, which can be a big downside. And there could be potential income and estate tax implications. For income tax implications, again, they're reporting income on the economic benefits that they've received, and estate tax implications if they own it outright. We also want to make sure that we have compliance with split dollar regs, again, on that endorsement side of things.
Hey, Tracy.
Yeah.
This is Gonzalo. Sorry, I can't
Yes.
get on camera, but in the world of a S Corp, you mentioned a transfer for value issue with SEBs for C Corps. Are there similar concerns with S Corps, and how do you get around that? And I want to ask you a follow-up question if possible.
Yeah, so yes, there can be implications for transfer value. Again, the consideration there is that economic benefit, or for the transfer value, it's any benefit that's conferred for with lack of consideration. So in these cases, we're reading that to be that endorsement and that requirement of economic benefit payment is a benefit that's conferred on the shareholders each year. And in the case of C corporations, the shareholder of the insured is not an exception to the rule. The partners of the insured is an exception. LLC members, if they're taxed to the partnership, is a verified exception as well. So that's usually where we strictly stay with the SEBs. Got it.
Okay, thank you for that. And there's a couple of questions. I think Kathy had lost her Wi-Fi, so I'm going to take over some of the questions here. One of the questions is, if you had entity-owned insurance and the entity sold the policy to the insured, avoiding the transfer for value as one of the allowed exceptions, and the insured then did the endorsement, would that solve the problem?
Not if it was a corporate scenario. So
C Corp.
Or
C or S or
C or
okay,
S.
got it.
So that would solve the issues as far as unwinding the entity buy sell, but only if it's going to be LLC taxed as a partnership or partnership partners interest there. So again, the problem is that endorsement is seen as a conference of value.
Right.
So we don't have that exception to the rule for corporate.
Got it. So you really want to stick to LLCs or partnerships in these situations?
Yes.
Not LLCs or partnerships taxed as an S Corp. If they made an S election, then you've got to avoid this, or maybe use an LLC, and we can certainly get into that in a minute. There were a couple other questions. Let me see here. In discussion with the valuation expert yesterday, this is the advisor asking the question, they will do a regular valuation for transaction purposes and add the gross insurance proceeds for the owner for estate values. For valuation for transactions, does this case have an impact if entity buy-sell is in place?
So valuations for transactions, I think the issue that we're running into, and that what the Supreme Court was trying to say was that there really wasn't a difference in valuation. That because the life insurance is considered an asset of the business up and until the death benefit is paid, the life insurance is included in the value because it is an asset.
Right.
What we've now learned is that the death benefit payable is also includable in that value as well.
Got it. Got it. Thank you for that. And then I know we've got about 10 minutes or 12 minutes left. I know you're going to cover the insurance LLC, but there's a specific question about that. What are the primary advantages of using an insurance LLC instead of a basic cross-purchase agreement? Maybe that's a good segue to move into the next section.
Absolutely. Everybody's kind of reading ahead in my notes. So the insurance LLC is really kind of where we think a lot of the industry is going. And again, there's still some open questions on this type of arrangement, but so far, what we've been getting back from the IRS has really been positive in using this type of arrangement. So ultimately, to kind of answer that question and to segue, is that really an insurance LLC is a cross-purchase arrangement. So at the corporate level, or at that main entity level, they would enter into a cross-purchase arrangement whereby each individual owner would personally be on the hook or personally be liable for buying out a deceased owner upon, or the departing owner upon death, disability, or retirement. So really we have that cross-purchase arrangement at the main entity. Where the LLC comes into play is that's really just the vehicle that we're using then to hold the insurance to fund those cross-purchase obligations. So how it technically would work from the insurance LLC structure is we would form an LLC, again, taxed as a partnership. That's where we get into those conversations about transfer of value and having those partnership carve-outs, as well as partnership tax from when we're liquidating assets, things like that have a pretty favorable tax component to it. From there, the owners would draft a cross-purchase buy-sell arrangement at the main entity level, and would purchase insurance on each other through the partnership itself. The partners or the business owners in this case would make ongoing payments of life insurance premium to the LLC, thereby increasing their capital in the LLC as well. And they'll leverage the insurance that's owned there on death or departure from the business. So again, it's always great to look at these things in terms of a case study, or I always learn best by drawing lines and connecting the dots. So that's what I'm going to try to do here as well. So for purposes here, the LLC really is just the funding vehicle to carry out a cross-purchase arrangement. So how does this work? So an LLC is created and is a separate entity designed exclusively to own and manage the life insurance policies to meet the obligations under that buy-sell agreement. So in this case, we're going to walk through with a little bit of a hypothetical. We're going to talk about Alice, Bob, and Carol. In this case, they're equal co-owners of Acme Anvil Company, valued at about $4.5 million. They enter into a cross-purchase arrangement, at the same time create an insurance LLC taxed as a partnership. We typically will see an independent manager or a CFO designated on the insurance LLC. That person is typically in charge of the administration of the LLC, so managing the insurance LLC for purposes of paying premiums, gathering information, coordinating any payouts, things like that. So really kind of an administration type role. Next, Alice, Bob, and Carol each contribute cash, in this case, in this scenario, to the insurance LLC in return for equal 33.3% membership interests. So there's a lot of flexibility in determining the source of those funds. So it could be as a bonus or a dividend, maybe a double bonus, under kind of those 162 arrangements from the business to those shareholders. We've also seen this as loans from the company to the LLC, similar to like in a split dollar loan arrangement for funding those premiums. In any event, there's, we're looking at, how do we get cash into the LLC? So once we've essentially, a third cash contribution to the LLC, that manager will go ahead and purchase one life insurance policy on each of Alice, Bob, and Carol. In this case, we've designated a $2 million contract, and then they'll go ahead and pay the premiums. So again, we do have a cross-purchase arrangement at Acme Anvil, but instead of Alice owning a policy on each Bob and Carol, and vice versa, Carol owning policy on each Alice and Bob, we're only owning one policy on each person, but managed at the LLC level. So the reason why we looked at a $2 million policy, even though Acme Anvil is only $4.5 million valuation, was keep in mind that each of them is going to need not only to liquidate their shares in Acme Anvil, but now they have capital contribution and they have a value of their shares in and an interest in that LLC. So there is a little bit of a kind of a hunt and peck there to try to figure out not only how much they're going to need to liquidate the shares of the company, but also liquidate their interest in the LLC upon that death, disability, or retirement. So if we look at kind of how this works at Carol's death, or redeeming Carol's interest in the LLC. So at the time that Carol dies, there's a $2 million policy paid into the LLC. Now, I know what you're thinking, we just talked about, well, that $2 million policy increases the value of that LLC, right? Well, under partnership law, there's a lot of different, I guess, flexibility that we have in creating the partnership and negotiating the membership interests and shares. So one of the things that's allowed in partnership is that it doesn't have to be an even split. So with shares and with corporate entities, one of the things we have with S Corp specifically is it has to be pro rata. That's not the case in partnership law. So in this case, we can write a special allocation into the partnership agreement or the membership interest, essentially stating that death benefit proceeds are excluded from the shareholders' interest if paid on their life. So in this case, it would not increase the value necessarily of Insurance LLC in this case, just because they had an ownership interest in that death benefit. Again, it may increase the LLC interest, but it won't increase Carol's interest in the LLC. I hope I explained that right. It gets really nuanced. So I start talking about it, and then I want to make sure that folks are kind of following that. So again, it's a special allocation in the partnership agreement from the outset that says that there's no interest in death benefits paid. So when we go to liquidate Carol's interest, the increase to Insurance LLC of that $2 million death benefits is excluded from her valuation or her interest in that LLC. So when we go to liquidate, we assume that Carol, her portion of that partnership, her 1/3 interest is $500,000, and that's based on the fair market value of those policies in whole as of the date of her death, but excluding the $2 million. We're going to then use that death benefit proceeds, again, liquidating Carol's interest in the LLC, but then Bob and Alice are going to use the rest of those proceeds to redeem Carol's shares from the Acme Anvil company, thereby essentially completing that cross-purchase arrangement for Acme Anvil. At the same time, because Bob and Alice are now purchasing those shares directly or facilitating through the LLC, they now have a step up in basis in those Acme Anvil shares as well that they wouldn't have otherwise gotten had Acme Anvil had an entity purchase arrangement. So that's what happens at death. It's a very similar kind of situation at retirement. So again, when we look at what's going to happen at retirement, in the case of the Insurance LLC, we can use the policy essentially as a distribution of their liquidation and interest. So in this case, if Bob is retiring, we can actually distribute the policy. He then takes that life insurance policy whole. Whatever the fair market value is essentially of that policy at that time, we're going to essentially determine that that's his liquidation of not only his shares in the LLC, but if the fair market value of that policy is greater than his interest in the LLC, then we're going to say that part of that distribution also redeemed some shares for Carol and Alice. So essentially using that excess to acquire the interest. So And in that case, then as a retiring partner, Bob now has this policy. There's potential cash value to use for retirement interests as well. Or because transfer to a grantor trust is an exception to the transfer for value rules, the insurance LLC could also, instead of distributing directly to Bob, could distribute to his ILIT as well, thereby avoiding that estate inclusion as well.
Hey, Tracey, kind of a related question to this, and I think the reference is also to Seb. So if you're looking at an LLC, can you combine the insurance LLC with a cross endorsement? So the question was, so were Bob and Alice renting $750K each of Carol's death benefit? So I think the question is,
Yep.
Are you bringing those two concepts together in any way, shape, or form, or maybe can you?
So in this case, I would say we're keeping them very separately. So nobody's renting anything because everybody is because the insurance LLC is the ownership. So
Right.
because the insurance LLC owns it, you don't really have an interest in any policy until there's a distribution from the LLC.
Right.
So whereas the difference in the cross endorsement is that you're endorsing the policy, essentially saying, look, if I die, you automatically get this. In this case, the insurance LLC is kind of that wrapper instead of the endorsement.
Got it. Tracey, I know we're kind of closing in on the top of the hour, and you may have a couple more slides here, but I do want to ask kind of one question before we begin to wrap
that
up.
was it. So if we want to move to questions,
go.
great. I just have prospecting tools and we can get this over to you, Gonzalo.
Thank you. Of course, the obligatory the note slide,
Yes.
Or footnote slide. So again, kind of as you think about all the advisors that are on the call that are talking to business owners who may have a stock redemption agreement in place, or corporate-owned life insurance to fund a stock redemption agreement in place, what's the best way to fix this? If should we be jumping in head on, or do we need to kind of take a pause and wait? Do you want to unwind stock redemption agreements and really start moving into insurance LLCs or SEBs if applicable? Kind of how would you suggest we best tackle this?
Yeah, and I'm going to give you the really frustrating attorney answer that it depends. And I say that just because, like I said, waiting for the courts to really figure out how to interpret this and how does it apply and in what scenarios does it apply? Are there any carve-outs? That's going to take a lot of time. Again, that's going to take the IRS coming in and auditing and then going through the tax court and kind of, if we keep in mind the Connelly case started in 2013 and we just got an answer this year. So I wouldn't necessarily say we have to wait to find out more answers. I think what's going to really come down to is, and what's very frustrating is that it's extremely client circumstance driven. So what do they have in place for the buy sell? Have they been following their buy sell? Did the entity redemption agreement make sense for other reasons than just the insurance portion of it? Do they have an estate tax consequence? What is the implications if that life insurance is included? For some folks, it may, for smaller businesses, that may not be an impact, but for larger businesses or higher valued businesses, it can be a very extreme implication. So it's going to be looking at, okay, so what's the value of those policies? Are they term policies? Or, does it make sense to keep them as key person and start over? Does it make sense to unwind it and move the policies out? Do we need trusts drafted to move those policies? Are we purchasing? There's so many questions that are still unanswered that I think the frustrating part of this is that we should definitely start talking to business owners, because as much as Connelly is, now a 4-letter word in our minds and top of minds, it's not that for business owners. They may not know that this happened and may not understand the implications that are coming down the line to them. So not only from getting in front of them to talk to those that have entity purchase, but also for those business owners that don't have a buy sell. This is something that we're always talking about and trying to beat the drum to get folks with business succession in place.
So Tracey, thank you. So my takeaway from that is that if you're doing business with business owners, or if you want to, a starting conversation would be, do you have a buy-sell agreement in place? Let's talk about it, because there was a recent Supreme Court decision that just came down that could potentially increase the value of the business and increase an estate tax problem that the business owners could have if we don't evaluate the buy-sell agreement to see whether or not that buy-sell agreement is going to be impacted by this Supreme Court decision.
Mhm.
As basic as that. Is that a fair statement?
That is very fair. And keep in mind, if they have an entity purchase agreement, it's not wrong. It's just may impact them differently.
Right. Terrific. We are at the top of the hour. It's 3:02. Gonzalo, you are on mute.
Well, one last quick question. I'm sorry. There was some questions around availability of slides and the recording, and I know Kathy's going to talk about that. But more importantly, all those slides say for producer use only. So is John Hancock working on something that will be client facing for use by everybody on this phone call?
I believe so. So let me check. We did finish a blog post. I don't know for sure if that's agent or client use, but it is available. We'll get that out to folks, and there is more coming. Again, this came out less than 2 weeks ago, and we're trying to process. So there will be lots more to come.
Great. Thank you, Tracey.
Thank
Back to
you.
you, Kath.
Thank you, Gonzalo. Tracey, thank you very much. As I said, we are at the top of the hour, and I just want to be respectful of everybody's time. This presentation and the recording will be available on the AgencyONE website, and you will be able to access it through that. If you cannot access it through the AgencyONE website, please reach out to Lisa Mitchell, and she will be able to tell you how you can access it. We're 6 months into the year, and there's a lot of planning that continues to be done and needs to take place before the end of the year. As everybody knows, we also have a looming sunset of the estate tax coming, and lots to talk about. So if you need any help, please reach out to Gonzalo, myself, any of your case managers at AgencyONE. We get phenomenal support from Wayne Baldwin, Tracey Ullom, and all of their colleagues at John Hancock. So they are here to help. Wayne will be the first one to say, did this case go to John Hancock? I want to see it. Can we look at it? So there's no better advocate than Wayne, and the advanced markets team is phenomenal. So Tracey, thank you for your time. And I think this has been extremely useful. If anybody has any questions following this presentation, again, please reach out to Gonzalo or myself. If we need to bring Tracey or Wayne back in, or any of Tracey's colleagues at John Hancock, they're happy to help. So Gonzalo, is there anything else you'd like to add? And I always like to give Wayne an opportunity to say something if he'd like.
Sure. First of all, thank you, AgencyONE, for the opportunity to address your elite group of brokers, and I truly mean that. I know most of them and met most of them, but seriously, thank you. And I'm glad we were able. You were the first BGA to jump all over this, by the way, and I thank you for that. So your brokers should appreciate how much you're on top of things and how important it is. So, and those brokers that are on the phone that's given us business this year, thank you very much. For those that haven't, what's up with that? Just kidding. But thanks again.
Tracey, again, thank you for your time and your expertise on this matter and your willingness to share. On behalf of AgencyONE, that's it. Thank you, guys. Take care. Have a good afternoon.